Welcome everyone to this webinar on disability discrimination and exclusions from protection under the Equality Act. My name is Helen Hogben and I'm a barrister with the employment team here at Trinity Chambers. Now, as we all know, the Equality Act 2010 gives wide-ranging protection from disability discrimination. But the purpose of this webinar is to provide guidance on those impairments which are in fact excluded from protection under the Act. The start point, as always, is the statute. Section 6 of the Equality Act 2010 provides that a person has a disability if they have a physical or mental impairment and that impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. And as we all know, it's not the label that you attach to the physical or mental impairment that counts, it's the effect. So, a person who suffers from a mental impairment that means they struggle to keep regulated or to concentrate doesn't need a formal diagnosis of, say, ADHD in order to potentially satisfy the definition of disability. However, under the Equality Act Disability Regulations 2010, there are certain conditions that are to be treated as not amounting to impairments. First, addiction. Under Regulation 3, addiction to alcohol, nicotine, or any other substance is to be treated as not amounting to an impairment for the purposes of the Act. Although this exclusion doesn't apply to addiction which was originally the result of the administration of medically prescribed drugs or other medical treatment. But in considering whether a condition is excluded, the primary focus, as I said, should be the effect of the impairment as opposed to its cause. And this is best illustrated by one of the examples given in the Equality Act 2010 guidance on matters to be taken into account in determining questions relating to the definition of disability. The guidance states that a person who is addicted to a substance such as alcohol may also have depression or a physical impairment such as liver damage arising from the alcohol addiction. While this person would not meet the definition simply on the basis of having an addiction, he or she may still meet the definition as a result of the effects of the depression or the liver damage. In the case of Power and Panasonic Limited from 2003, the claimant was off work and was later dismissed due to both depression and alcohol abuse. The Employment Tribunal had dismissed her claim of disability discrimination, and on her appeal to the EAT, it was argued that the tribunal erred in its approach and that they had focused on whether she'd been clinically depressed first and later turned to drink, or whether it was the other way around. In that case, the EAT upheld the claimant's appeal, stating that it was immaterial how an impairment was caused. Similarly, in Hutchison 3G UK Limited and Mason from the same year, the EAT upheld the decision of the Employment Tribunal in a case involving a claimant who was addicted to cocaine and also had clinical depression. The claimant succeeded in his claim on the basis that his depression was sufficiently causative of his absence from work, and that the dismissal because of his absence from work related to such disability and was accordingly discriminatory. Second, hay fever. Now, this is a relatively straightforward exclusion. Under Regulations 4.2 and 4.3, hay fever shall be treated as not amounting to an impairment unless it aggravates the effect of any other condition, for example, a lung condition. And third, exclusions under Regulation 4.1. Now, much of the case law on this issue has centred around the exclusions set out in Regulation 4.1 of the Equality Act Disability Regulations 2010. It says that the following conditions are to be treated as not amounting to impairments: a tendency to set fires, a tendency to steal, a tendency to physical or sexual abuse of other persons, exhibitionism, and voyeurism. Effectively, what this means is that at face value, a tendency to do any of those things may well be mental impairments in themselves, but they are excluded from protection under the Equality Act. The leading authority in an employment context is Edmund Nuttall Limited and Butterfield from 2005, a pre-Equality Act case but still good law. In that case, the claimant had brought claims for less favourable treatment on the grounds of disability and unfair dismissal. At first instance, the Employment Tribunal found that the claimant, who'd been convicted of the criminal offences of indecent exposure, had committed those offences because he had a mental illness, namely depression. They upheld his claim of disability discrimination on the basis that had he not been suffering from mental illness, he would not have committed the offences. But the EAT and Butterfield formed a very different conclusion. In considering the employer's appeal, the EAT rejected the claimant's submissions that the exclusions in the regulations refer only to freestanding conditions and not to those that are the direct consequence of a physical or a mental impairment. A claimant may have both a legitimate impairment, for example depression, and an excluded condition. The critical question was one of causation. What was the reason for the less favourable treatment? If the reason was the legitimate impairment, then prima facie discrimination, subject to any defence, for example, of justification, is made out. If the reason is the excluded condition, then the claim fails by reason of disability. And if the reason was a mixture of the two, but the legitimate impairment was an effective cause, then again discrimination was made out. And in Butterfield, the Employment Appeal Tribunal held that it was clear on the facts that the sole reason related to the excluded condition, i.e. the indecent exposure, and the finding of disability discrimination was set aside. Education cases. In education cases, some caution needs to be adopted when approaching cases involving disability discrimination in schools, particularly those involving pupils with special educational needs and disabilities. I practice in the SEND Tribunal and I'm seeing an increasing number of claims of disability discrimination being brought against schools, which is perhaps unsurprising given the significant increase in the number of children in mainstream settings who were either on the SEND register or have an EHC plan. In the case of Governing Body of X Endowed Primary School and the SEND Tribunal from 2009, again a pre-Equality Act case, which I'll refer to in this webinar as the first X case, a primary school child with ADHD was permanently excluded from school following an assault on a teacher. His parents brought proceedings against the governing body in the SEND Tribunal, who found that the governing body had unlawfully discriminated against the child on the ground of his disability in failing to make reasonable adjustments by enlisting the advice and support of the Access to Learning Specialist team prior to the incident which led to his exclusion. On appeal to the upper tribunal, the governing body argued that his impairment fell within Regulation 41C of the Equality Act Disability Regulations 2010, namely a tendency to physical abuse of others, and therefore was excluded from protection under the Equality Act. There are three important points to note from the High Court decision in that first X case. Firstly, the court affirmed the principle that exclusion from protection under disability discrimination law was not limited to freestanding conditions. Second, they said it was important to examine whether the alleged discrimination relates to a protected disability or an excluded condition, or to both. If the discrimination relates to a protected disability, or to both a protected disability and an excluded condition, then the discrimination is unlawful. Now, in the first X case, the reason for the child's exclusion was for assaulting a teacher, and it therefore related to an excluded condition. But third, and significantly in that case, it was important to look at the particular type of discrimination complained of. The parents had also successfully claimed that the school had failed to make reasonable adjustments, in that it failed to enlist the advice and support of the Access to Learning team prior to the incident which led to his exclusion. And that intervention included measures that went beyond controlling his tendency to physical abuse, but also included general strategies for the management of pupils with ADHD, which included strategies for dealing with disruptive behaviour which fell short of physical abuse. And accordingly, the appeal brought by the governing body in respect of the successful failure to make reasonable adjustments claim was dismissed. Now, following the first X case, the Equality Act 2010 came into force, along with the Equality Act Disability Regulations 2010. And they mirrored the earlier primary and secondary legislation under the Disability Discrimination Act. The Secretary of State also issued the Equality Act 2010 guidance on matters to be taken into account in determining questions relating to the definition of disability. Now, whilst that doesn't impose any legal obligations in itself, paragraph 12 of Schedule 1 to the Act requires that an adjudicating body which is determining whether a person is a disabled person must take into account any aspect of the guidance which appears to it to be relevant. Paragraph A12 of that guidance, which was last updated in 2013, gives a case study of how Regulation 4.1 works in practice. The example given is that of a young man with ADHD, which manifests itself in a number of ways, including exhibitionism and an inability to concentrate. The disorder, as an impairment which has a substantial and long-term adverse effect on the young person's ability to carry out normal day-to-day activities, would be a disability for the purposes of the Act. However, the statutory guidance goes on to state that the young man is not entitled to the protection of the Act in relation to any discrimination he experiences as a consequence of his exhibitionism, because that is an excluded condition under the Act. However, he would be protected in relation to any discrimination he experiences in relation to the non-excluded effects of his condition, such as an inability to concentrate. For example, he would be entitled to reasonable adjustments that are required as a consequence of those effects. It is against this background that the Upper Tribunal once again considered the scope of Regulation 4.1c in the case of X and the governing body of a school from 2015, which I'll refer to as the second X case. In that case, the Upper Tribunal gave guidance on how tribunals should approach the issue of whether a person has a tendency to physical abuse of others. It said, inter alia, in addressing whether a person has a tendency to physical abuse of other persons, a tribunal must consider all of the circumstances of each individual case. They noted that Parliament had chosen not to use the phrase physical violence, and whilst they inferred that there must always be an element of violent conduct, that on its own may not necessarily be sufficient to meet the definition. Of course, the greater the level of violence, the more readily it will fall within the meaning of physical abuse. Importantly, the Upper Tribunal stated that whilst children are, as a matter of law, included within the ambit of Regulation 4.1c, nevertheless, the stage of a child's development is a factor which will fall to be considered in deciding whether or not that particular child has a condition so as to bring it within the remit of the regulation at all. However, if the child does have such a condition, then insofar as the child's conduct manifests a tendency to physical abuse of other persons, it will fall within the terms of the regulation. Now, what was common to both the first X and the second X cases was that whilst the Upper Tribunal concluded that Regulation 4.1c could include children with impairments which manifested a tendency towards physical abuse, in neither case had there been any discussion of the compatibility of that provision with Article 14 of the European Convention on Human Rights. Article 14 provides that the enjoyment of the rights and freedoms set forth in the Convention shall be secured without discrimination. And of course, the relevant substantive right in a school's context is the right to education set out in Article 2 of the First Protocol. That compatibility issue was considered by the Upper Tribunal in the case of C&C and the governing body of a school from 2018. That case concerned a child with autism, anxiety and pathological demand avoidance who'd received a fixed-term exclusion for aggressive behaviour which resulted from his condition. The first-tier tribunal had originally dismissed his discrimination claim, relying on the exclusion from protection as a result of his tendency to physical abuse. But the Upper Tribunal said that that was wrong and that it violated his convention rights under Article 14. The Upper Tribunal held that the Secretary of State had failed to justify maintaining in force a provision which excluded from the ambit of protection of the Equality Act Children whose behaviour in school was a manifestation of the very condition which called for special educational provision to be made for them. Accordingly, the upper tribunal concluded that in the context of education, Regulation 41C violates the Convention rights of children to education where they have a recognised condition that is more likely to result in a tendency to physical abuse. It further concluded that whether Regulation 41C was read down under Section 3 of the Human Rights Act, or whether it was disapplied, the excluded child in this case did meet the definition of disability under the Equality Act 2010. So moving forward from that case, it would seem clear that so far as education cases are concerned, children in schools who have a tendency to physical abuse of others as a result of their impairment are not excluded from the protection of the Equality Act. In bringing this webinar to a close, I would just like to offer a couple of tips for those dealing with cases of this nature, whether in an employment or in an education context. First, don't take things at face value. It's tempting to simply conclude that if a claimant is addicted to alcohol, for example, that must be an excluded impairment. We need to explore the wider context and whether there are any accompanying or related conditions, like depression, say, that could qualify for protection. Second, always look at the basis of the claim and the type of discrimination being complained of. And the education cases that I've cited here are really helpful illustrations. And finally, take particular care when advising schools. Following C&C, children in schools who have a tendency to physical abuse of others as a result of their impairment are not excluded from the protection of the Equality Act 2010. That's not to say that schools can never have a valid defence to any disability discrimination claim. For example, a child excluded for violent behaviour towards others can still be lawfully excluded if that measure was a proportionate means of achieving a legitimate aim. That concludes this talk on disability and exclusions from protection. I do hope it's been of use, and thank you very much for listening.